I'm a little concerned about what I see as a conflation of the different prongs in your argument. You've said a couple times that what we should be looking for is acting under conduct, or did the defendant commit those acts while acting under a federal officer? And that's not the way I understood the statute to be read. I thought acting under was one prong, and it was related to the authority that you have as this defendant, whether you're a federal officer yourself or you're not, but you are acting under the authority of the federal government. And then we have the for or relating to any act. Mr. Clement says the who, the what. I see that, and you, I think, are collapsing them. So can you help me to understand why you're not?
Sure. So if I could give you a textual response based on the statute, and then just a response based on practice from the asbestos cases. So just as a textual matter, Your Honor, I think paragraph 1 in our red brief was very delicately crafted, because I think the right way to interpret the statute is to say, it's a focus on the subject in the prefatory language in 1442A1. If you look at Pet App 182, the very first sentence, right, the subject there is a civil action. And then the rest of A1, what it's doing is telling you which civil actions may be removed. Now, my friends on the other side want to make prong 1 about who can remove and prong 2 about what suits can be removed.
But doesn't that follow from our case law? I guess I can't figure out how Willingham comes out the same way if you're right.
Right, Your Honor. So what I'm saying is that on our view, if you say that the rest of A1 basically asks which actions can be removed, prong 1 is which action. The action must be against a specific defendant. And the textual point I made in my opening is that if you take that phrase, a civil action commenced against a person acting under a federal officer, implicit in that language is a presupposition that that defendant has acted under a federal officer. Where do you go to find whether that defendant actually acted under a federal officer? The complaint is the one that actually commenced.
Are you saying that the act must be directed by the federal, the act in question has to be directed by the federal officer in order to give grounds for removal?
No, Your Honor.
Is that what you're saying?
No, Your Honor.
Okay.
And that's why I think that, this attack from the other side on that point is a bit misleading. So let me go to the asbestos cases, because we actually agree with pages 31 and 32 of Mr. Clement's.
But I mean, that is what the Fifth Circuit said here, didn't it? I mean, that was the basis for the Fifth Circuit's ruling, was that the production of the crude was not directed by the contracts. And so that's why, right? I mean, am I wrong about that?
So I think you're right, Your Honor, but I think what the Fifth Circuit was recognizing is the mismatch problem that we outlined in our red brief. They tried to solve that problem at prong 2, and our humble submission was that you should just solve that problem at prong 1. Now, if I could tell you why I agree with Mr. Clement's description of the asbestos cases and how they shake out pre and post 2011, remember the basic fact pattern in those cases is you've got a federal contract that says, contractor, you go refurbish a Navy ship and you install asbestos. So pre-2011, if there's a failure to warn claim about the asbestos being installed, the courts say, and the Lachiole panel in the Fifth Circuit, which had that same fact pattern, said, this doesn't suffice for federal officer removal because the claim is not for an act that was directed by the federal government. Now, post-2011, you've got related to, and as Mr. Clement says, once there's a failure to warn claim, it may not be that the federal government said specify these warnings or don't include warnings, but that doesn't matter. And that's why you have the outcome in Lachiole 2, the en banc decision from the Fifth Circuit that says, look, when you engaged in the act of installing asbestos, unquestionably, that is an act under a federal officer. That's prong 1. And so the only question remaining is prong 2. Is your failure to submit safety warnings or submit safety gear to your employees related to that act under a federal officer? That's why I think, the idea that our theory somehow dooms federal government contracting as we know it doesn't hold up, because we're perfectly consistent with the asbestos cases that I think are the prototypical cases where you're going to see government contractors come to court and say, we deserve to be in federal court because we, installed asbestos pursuant to the government's contract. I think that's the important piece. Justice Jackson, you asked about but-for causation. I'd like to talk about like the test for my friends on the other side and trying to answer the court's limiting principle questions about like, how far does relating to go. Now, I'll pick up where Mr. Clement did, which was with his colloquy with Judge Engelhardt at the very end of oral argument in the Fifth Circuit, where Judge Engelhardt asked him, are you basically saying that this is a but-for causation standard? And Mr. Clement says yes, as he says today. And I was a bit taken aback by that because they don't have a but-for causation argument in this case. Think about it. There is no argument that but for the avgas refining contracts, they would not have engaged in, for example, dumping produced water from oil wells into the marsh. One way we know that, if you look at the PAW history book, look at page 176, 189, what that history recounts is that 70% of the nation's crude oil was actually going to civilian use, not military use, civilian use. Our expert cites that at JA 67, and the whole point is that like industry would have been engaged in the exact same conduct that we charged in our complaints, whether or not an avgas refining contract existed. And I think, to your point, Justice Barrett, about open questions in the case, that is one of the most important things, because for all of the narrative from my friends on the other side that, this was a natural consequence of their avgas refining contracts, that is inconsistent with the historical record. And so I think, that's the answer on but-for causation, Your Honor. And so if that's the outer limit of their test, then as a factual matter, whether we win it here or we win it back on remand, we're going to win that issue because there is no argument that but for the avgas refining contracts, they would not have engaged in, for example, the dumping of produced water into the marsh. Now, the other thing I would add to that is just the argument that, I take my friends, and we talked about the narrative in World War II. There was a line from Judge Oldham in dissent below that said it's hard to tell how they would have been able to satisfy their avgas refining contracts if they had not produced oil. And respectfully, that too is directly contrary to the record. For one thing, just look at pages 217 and 218 of the PAW history book. The problem, and this is a section called the Gulf Coast Surplus, the problem that Louisiana refineries had during the World War II era that my friends want to focus on is they had too much oil. There wasn't enough transportation to take oil throughout the rest of the country, and that overstimulation, that oversupply of oil on the Gulf Coast meant that there was a serious concern that the refineries would actually have to close for lack of storage capacity. That's in the PAW history book, and what they say is that throughout the war, the refineries actually had to operate at 70% capacity of pre-war levels just to avoid this oversupply of crude oil running them over. I take my friends, I understand they want to make this case about World War II. With all due respect, our experience in the Point Lahash trial in Plaquemines Parish and the historical record, the sites I just gave you directly contradict that narrative. And if the court has no further questions, Mr. Chief Justice.